Supplementary list, item number 1, pronouncement of judgment.
I'll read only the. You can go through the judgment and see the findings and observation. In view of the observations and discussion made here and above, this court is of the considered opinion that the impugned order dated so-and-so as well as the order dated so-and-so have been passed beyond jurisdiction and not in conformity with the accepted procedure. The same are hereby set aside and quashed. Consequently, the prayer of the petitioners in this regard is hereby allowed. I think there was something wrong with the procedure adopted. You tell me, if a petition is filed to change the name, how can that be considered a review? A review petition. You go through this.
Much obliged.
Okay. Yes.
Your Lordship, I beg to mention item number 3. Mr. Shulai is leading this matter, Your Lordship, and he's in bereavement.
Okay. Mr. Leonard G has sought for accommodation on the ground that the Leonard that Mr. Andy Shulai, Leonard AG, who is conducting the matter, is in bereavement. Prayer not being objected to by petitioner, the matter is accordingly adjourned. Let's see him after 2 weeks.
Obliged, Your Lordship.
Daily list, item number 1. May it please Your Lordship. Your Lordship, we pray for some more time, Your Lordship, to file a response. Lordship, we received instructions just this morning, Your Lordship, in this matter, actually.
My Lord, my humble submission to what my learned friend has said, my Lord, I strongly object, my Lord, because on the last occasion also, my Lord, they have frequently seeking time. When this matter, my Lord, was listed before the previous bench, the same, and when it's listed before my Lord also, they have sought time again and again for just for filing the reply, my Lord. On the last occasion also, I prayed before this court, only 1 week time to be allowed, my Lord, and additionally, my Lord had graciously granted them 2 weeks time to file, my Lord, the affidavit, my Lord. And again now, my Lord, they are seeking time again and again. And this is a matter of default bail, my Lord, to set aside the order of the trial court, my Lord. Just that much, my Lord. Nothing much involves, my Lord.
Default. Oh, if I remember correctly, it's a question of that calculation.
Calculation of dates, yes, my Lord.
Your Lordship, just some more days, Your Lordship, because we just received instructions this morning itself, Your Lordship. I had also stated in the last order also, Your Lordship, that because the instructions come from the DRI, Your Lordship, and instructions I received just this morning, Your Lordship. We just need some more days, Your Lordship. We'll file the.
You may see as Ms. Nausi has.
Yes, Your Lordship.
Firstly, you have to understand that bail matters are of prime or rather utmost consideration if it is taken up before any court. Number 1. Number 2 is time has been allowed to you. I don't know whether it's the second or third or fourth time. By that time you could have got your instructions.
Your Lordship, I have actually tried, Your Lordship, but this morning itself. Just some more days, Your Lordship.
Okay, last chance and
Yes,
no more.
yes, Your Lordship.
My Lord, just
why
1
would you
week
file a
time.
response? I wonder.
Your Lordship,
This is an application in the 42
Yes, my Lord, to set aside the order of the Leonard trial court. Yes, my Lord.
for quashing of the
order for quashing of default bail order, my Lord, because it was wrongly decided, my Lord, on the calculation of dates. Yes,
only for default bail.
yes, my
Not
Lord.
for the proceedings.
Not for the proceedings, my Lord. Only to quash and set aside the order of the default bail, my Lord.
Order of the default bail means you've been allowed to go on bail.
I have not been allowed, my Lord.
The order
Yes, the order is at page 8.
refusing to allow
Yes.
you to go on default bail.
Yes, my Lord, yes.
Mr. Learned Counsel, appearing on behalf of the respondent, has once again sought for accommodation in this matter on the ground that the instructions received from the on the ground that the instruction as sought for has been conveyed by the DRI. The DRI is the prosecuting agency.
Yes, Your Lordship.
DRI, the prosecuting agency, only today, and as such, the response could not be filed immediately. Ms. SNOC Learned Counsel for the petitioner has objected to the prayer made on the ground that time and again the respondent has sought for accommodation on this sole ground. However, this court, on consideration of the submission made, is also inclined to allow the parties a full opportunity to be heard and to place the case accordingly. As such, the prayer for adjournment is allowed. However, it is made clear that no further adjournment will be allowed on the next date fix.
My lord, next Friday, my lord, if possible. 27. Friday.
Yeah. On prayer made by the parties, list this matter on 27th.
Highly obliged,
In
my
the
lord.
meantime, you can file that and advance copy of the petition.
Yes, Your Lordship.
We will not waste time.
Yes, Your Lordship.
Highly obliged,
Your
ma'am.
Lordship. Item number 2.
Lordship, this is that sand dispute matter, Your Lordship. I don't need River, Your Lordship. This is that sand dispute, Your Lordship.
Sand dispute.
Lordship. Where the
What is
additional
the
judge held that this is revision petition against the order of the additional district judge, district council court, Your Lordship.
What is the impugn order?
Impugn order is Annex 5, 28/12/2019.
Page?
Page 169, Your Lordship.
Oh, this is the final judgment.
Lordship.
Final judgment order.
Lordship.
None appears for the petitioner. Mr. Learned Counsel for the respondent has submitted that this matter may be posted to the next date. Posted the next date. Accordingly, as prayed for, this is matter after 3 weeks.